Before this courtroom drama even begins, let's set the stage for what you're about to witness. This case might look simple at first glance, just a dispute over unpaid money, but what unfolds in this courtroom shows how quickly things can escalate when frustration, legal obligations, and attitude collide. At the center of this case is a woman named Tracy Linville, who owes money following a court judgment. The plaintiff, Virginia Swindle, is trying to collect what she believes she's rightfully owed. Sounds straightforward, right? But when the judge calls the case back to court for something called a creditor's examination, things take a tense turn almost immediately. A creditor's exam is serious business. It's when someone who won a judgment gets to question the person who owes money about their finances, where they work, how much they earn, what assets they have, all under oath. The goal? To figure out how the debt will actually get paid. But from the very first moment in this courtroom, you can already feel the tension building. The judge notices body language, frustration, and what appears to be disrespect toward the court. And trust me, judges do not take that lightly. What starts as a routine financial hearing quickly turns into a heated exchange about responsibility, court orders, and courtroom behavior. So watch closely, because the way someone acts in front of a judge can sometimes matter just as much as the case itself. And here's a question for you right from the start. If you owed money from a court judgment, would you approach the situation calmly, or would frustration get the best of you? Let's see how this situation unfolds.
Don't roll your eyes at me, Miss Linville. Miss Linville. Miss Linville. I said your name. Come back here. You don't get to go out of here and sit down. Right there, sit. You don't get to go out of here rolling your eyes, disagreeing with this judge's decision, announcing that you're not a criminal, and then storming out of here and pulling doors open where they're hitting the pews. You got it? We're still Virginia and Swindle. What is going on? How much have you paid this judgment in full, Ms. Linville? Your name?
Tracy Linville.
Your name?
Virginia.
Have you paid this judgment in full?
I was paying every single week. I got attacked by a husky and broke my hand. I couldn't work. I sent her a letter that day, and I sent her several letters.
Well, this is up for a creditor's exam today. You realize that?
I could continue.
Let's pause here for a moment because this is where the legal mechanics of the case start to matter. Tracy claims she was paying regularly but had to stop after being injured in a dog attack that left her unable to work. Situations like this can happen. Life throws unexpected obstacles at people all the time. But in the eyes of the court, the key issue isn't just what happened. It's whether the court order was followed properly. When someone owes money from a judgment, the court expects consistent payments unless the order is formally changed. That means the debtor usually needs to file a motion explaining the situation and asking the judge for a modification. Simply sending letters or stopping payments without official approval can cause serious problems legally, and that's exactly why this hearing is happening today, a creditor's examination. The court wants transparency about finances so the creditor can determine whether the debt can be collected through wages, assets, or payment plans. Now here's something interesting to think about. Do you think unexpected hardships should pause? A court-ordered payment automatically? Or should the legal system always require formal approval first? Let's keep watching.
Continued paying her within 6 weeks because you told me that to deal with her, that she was in charge now.
Well, I didn't say she was in charge. I wouldn't use that word.
Well, you said you didn't want to see it back in here.
Well, I didn't say that.
Well,
I didn't appoint her judge. You're not suggesting that, are you?
No.
Okay.
I sent her several letters. And
Ma'am, listen.
I was able to.
Ma'am, listen. She has the right to conduct a creditor's exam today. Okay? You received a subpoena. See this? Subpoena? Order to produce, order to appear and or produce.
I've been waiting for you for this. Cause I wanted to pay her. I told her within 6 weeks, I was back to work, I'd pay her.
No, but when was the judgment entered? December,
Judge,
go
I
ahead.
was going to say, Judge, if I may, there was a order for installment payments entered in June of
Right.
last year. And then in October, Ms. Swindle filed a motion to set aside. In October 23rd, there was an order setting aside the payments.
You're here for a creditor's exam. Did you bring everything you were supposed to in the subpoena?
I brought all of my documentation.
Okay. Here's what I'm gonna do. Ms. Swindle, you're gonna get to go in a room and ask her questions. Do you understand that?
Yes.
I'm gonna ask you to raise your right hand, Ms. Linville. You don't have to raise your right hand, Ms. Swindle. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes.
All right. You guys go in a conference room. You can ask her all the questions you want. You can look at all those documents. And then you guys can come out here and tell me that everything did or didn't go well. Okay? That's what I'm gonna have you do. My court officer will show you a conference room. Thank you. All right, Ms. Swindle, your name? Ms. Linville,
Tracy, Linville.
did everything go okay in there? Did you get to ask her questions? Did she answer your questions?
Yes, she said she didn't have the information she was supposed to have.
What did she have? You gotta go get it.
She didn't ask questions, she wanted to know about the accident,
What?
she asked me her questions.
Wait a minute.
About
Where's your job address? Where do you work?
I don't have the job address. I told her I was there 150 a week.
Ma'am, she gets the garnish wages.
I'm gonna go here. This is bad,
Nobody's.
game.
You don't get to refuse to answer questions. You don't get to refuse to answer questions.
I don't, I.
Ma'am.
All right.
Let me.
Things just escalated dramatically here. What you're seeing now is the judge drawing a very firm line about courtroom authority and compliance with a subpoena. During a creditor's examination, refusing to answer questions isn't really an option. The subpoena legally requires the person to provide financial information, including employment details and income. When the judge repeatedly says, "You don't get to refuse to answer questions," that's not just frustration. Speaking, that's the court reinforcing the power of its orders. Ignoring those orders could potentially lead to sanctions, contempt charges, or even wage garnishment. But there's another layer happening here too. Attitude inside the courtroom. The judge is reacting strongly to eye-rolling and walking away while court is still in session. That might seem small, but judges see that as direct disrespect toward the court. And moments like this often shape how a case moves forward. So let me ask you something. Do you think the judge is being too strict here? Or is this exactly how courtroom authority should be enforced? Because this situation is about to determine whether the debt gets paid and how.
Let me just reiterate. You don't have the opportunity to refuse to answer questions here. This is a subpoena. Where do you work? And what is the address? Go find it. Go find it. I'm telling you, go get the address and come on back in here. You got a subpoena. And I'm not going to don't roll your eyes at me, Ms. Linville. Ms. Linville. Miss Linville. I said your name. Come back here. You don't get to go out of here and sit down. Right there, sit. You don't get to go out of here rolling your eyes, disagreeing with this judge's decision, announcing that you're not a criminal, and then storming out of here and pulling doors open where they're hitting the pews. You got it?
Sorry. I'm very sorry. She worked me out very bad.
You don't get to do that. I'm telling you, go get all this information.
Yeah.
Go get it and come on back in.
go out.
Yeah, quietly, nicely, not in a tiff. Gorham versus TransUnion LLC, 2504914. All right, any resolution on this? Ma'am, your name again?
Danielle.
Your name?
Tracy,
Do you have your bank accounts?
no.
Go get it. Go get it. She didn't subpoena them. But she can do this again. Just pay her the money. How much does she owe you, Miss Swindle?
Want to.
I'm still over 2,000.
Well, you're not doing a very good job. How much was the judgment for?
3,000.
3,136.
$136.
Yeah, say something.
You guys are making this hard. I've seen you guys more on this little case. I can't even tell you how many times. I want you to pay her. I want you to pay her. Well, you didn't pay October, November, December, January, right?
Fortunately, I had to wait for this to come through.
And just
I
like
can't hear-
that, the courtroom tension settles into a final ruling. After all the back and forth, the judge ultimately chooses a practical solution, reinstating weekly installment payments. Instead of immediately allowing wage garnishment, the court gives Tracy another chance to repay the debt gradually, ordering payments of $100 per week starting March 2nd. This is actually a common outcome in civil judgment cases. Courts generally prefer structured payment plans because they allow debts to be repaid without immediately resorting to harsher collection methods like garnishing wages or seizing assets. But there's an important warning attached. If those payments stop again, the creditor can return to court and request wage garnishment. So in the end, the message from the judge is crystal clear. Follow the payment schedule, stay cooperative, and respect the court process. Now we want to hear from you. Do you think the judge handled this situation fairly? Should the court have allowed wage garnishment immediately, or was giving another payment plan the right decision? If you found this case as intense and revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns right here on Crime Docs, because the next courtroom story might be even more unbelievable.
I came in here twice.
Do you have an installment payment order down there again?
Every week from when you started it until I hand her over.
Yeah.
Good morning.
Jennifer's not down. Are you down there, Jennifer?
Yes, Judge, I just got out of the
I
breakout
need you to
room.
prepare an installment payment order. How often you get paid?
Every week.
Every Friday?
Yes.
How much can you pay every week?
I was paying $100 every week.
Let's put it down for $100 a week again. Next
Okay,
time you'll
it'll
be able
take me
to
a couple minutes to type the order, Judge.
Yeah, and then my courthouse will get it. You both can look at it if you agree to it. This is easier for both of you, but you got to stay on your payment schedule. Otherwise, I'm setting aside the installment payment order, and she's going to be able to garnish your wages. Is that okay with you, Ms. Swindle?
Yes.
All right, she's going to prepare the proposed order. You two are going to look at it. I'm going on to another case, and we'll go from there. Okay? Thank you both. Jeez. All right, so I'm going to consider this an oral motion. You want to pay weekly installment payments, correct?
Yes.
And you get paid every Friday. Can you start this next Monday? That would be March the 2nd. There's no, Jennifer, there was never a garnishment issue here, right? I don't have to worry about
Correct,
that.
there hadn't been one yet, no.
I'm going to go ahead and order. I don't need you guys to sign this. You pay $100 starting on March the 2nd. So I'm going to indicate you filed an oral motion with this court on February the 24th or 26th. You have to pay this judgment every week starting March 2 of 26. You can each go down the hall. They'll give you a copy of the judgment for your records. make sure you stay with that. If she doesn't stay with that, Ms. Swindle, you can, file a motion to set aside the installment payment order. And then I'm gonna let you garnish wages, okay? We understand one another?
Yes.
We understand one another? Good enough.
Sorry.
All right, have a good day. Thank you. It's John. You guys go down the hall and they're gonna give you a copy of that order. Mr. Gates, you don't have anything for me, do you?